You decided to sue your doctor and hospital staff for being careless and causing you significant harm and injury. And now you are told you will have to appear for a pretrial deposition. What can you expect? What should you expect in a pretrial deposition? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. First of all, a deposition is a question and answer session that's given under oath. Typically in pre-COVID times would take place in your attorney's office. During COVID times, it often takes place on a Zoom video call. It is sworn. Your answers represent sworn testimony. And now, why is that important? It's important because this is the very first time that the defense, the opposing attorneys, have an opportunity to hear from you exactly what happened to you in your own words. It is really the very first time that the opposing attorneys will have an opportunity to learn from you, in your own words, about exactly what happened to you and why. They will learn what injuries you have as a result of whatever was done wrong, and how those injuries have affected you on a daily basis. It is an incredible opportunity for you to share with them everything that you can and cannot do. Now, there's also another key reason why the defense wants to go ahead and question you during the course of your lawsuit. You want to know what that is? It's the ability to lock in your testimony. Now, what does that mean? Every time you give an answer, you have sworn to tell the truth. Now, a year or two down the road, when and if your case goes to trial, you will likely be asked very similar, if not the identical questions that you were asked during the course of your pretrial questioning, your deposition. By the way, lawyers also call it an examination before trial. If the answers that you give at trial deviate and are different from the answer that you gave back when you testified under oath during your pretrial deposition, well, guess what? Now the defense turns around and they've established what we call a contradiction. The goal here is to lock you into your testimony. And if the answer that you give during the course of trial now differs from the answer that you gave to the same question during your deposition, now the defense will use that to show the jury that you are being less than truthful, that now there are contradictions and your credibility is shot. The defense uses this to lock you into your testimony. Now, what else can you expect? I will tell you that some clients, some injured patients who bring these types of lawsuits are terrified. They are actually terrified to go ahead and answer these questions. They think it is similar to being in court and being cross-examined by the opposing attorney. They think the opposing lawyer is going to start screaming and yelling and cross-examining them and putting them down and bullying them. Well, I will tell you, in almost 34 years of practice, that happens in a very, very, very small percentage of time. And when it does happen, we push right back. And the attorneys are supposed to be polite. They're supposed to be professional. And I will tell you that for the majority of them, they certainly are. And it tends to be not pleasant, but it tends to be a very professional attitude. And you know something else that I noticed? I find that the very best defense attorneys tend to be understanding when they question an injured patient. They tend to be a bit sympathetic and sometimes even say, hey, Mrs. Jones, I'm so sorry you had to go through this, but I have to ask you these questions to understand what happened to you. Is that okay with you? And why do they do that? Because they want you to feel a bit more relaxed. They don't want you to be all uptight and answer, yes, no, I don't know. Why are you asking me that question? They want you to talk. And the more they get you to talk, the more information that they will have, as well as the more information that will allow them to lock you into that testimony. So it is a double-edged sword. Because remember, everything that you say in response to these questions will be used against you. Now, this is not a criminal case where you're arrested and now part of the Miranda warnings where the police officer says anything you say can and will be used against you in a court of law. It's ironic that in a deposition, anything that you do say in response to the questions that are asked of you is your sworn testimony. And if it contradicts something later on, now you better believe it, the defense is going to use that against you to try and show that you're being less than truthful. Okay, what else can you expect in a deposition? You can expect that the defense attorney is going to ask you about your medical history. You can expect that they're going to ask you about your schooling, the highest level of school that you have achieved. They will also ask you about your work history. The defense attorney is going to ask you a lot of things that you think are totally unrelated to the issues in this particular case. Why? Because they need to find out information. They need to learn about who you are. They need to understand where you come from and what you've done in the past. Many of these things will not be allowed to be used at trial if your case goes to trial. But because this is the discovery phase of your lawsuit, they are often entitled to ask lots of questions that you believe have nothing whatsoever to do with the claims that you are making or with the defenses that they have raised. So why do I bring this up? I bring this up just to give you a clear understanding of what you can expect to happen if you bring a lawsuit against a careless doctor or careless hospital staff, and now you're asked to give a deposition. You know, I realize you're likely watching this because you want to see the beautiful scenery. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.